Hey, good afternoon, everyone, and thanks so much for joining us. What we hope will be a series of informative business immigration and self-sponsorship webinars in the future. Before I introduce today's speaker, just some housekeeping. Everyone is muted by default and your cameras are off. You'll only be able to see the presenter speaking as opposed to the other attendees. You can click on the top bar with the 2 arrows to maximize your screen should you wish to. There's also a chat function at the bottom. We have ensured that the chat is private, so please feel free to ask any questions that you may have. We will do a Q&A after the session. If you have direct, specific, or sensitive questions, our contact details are also shared, so you're welcome to reach out for a free, no obligation consultation. To give you a brief overview of us as Sable International, we are specialists in immigration and international financial services and have been providing our boutique range of services for over 30 years. We have offices around the world and are generally able to provide a bespoke, customer-centric service suited to a range of clients. Before I introduce today's first speaker, the agenda for today will be on business immigration and all the routes available to foreign businesses wanting to expand to the UK. We'll also be exploring how that foreign entity can be used under self-sponsorship, enabling that entity to become an immigration vehicle to ultimately relocate to the UK and become British. It's now possible for a UK business to be set up, registered as a licensed sponsor, and used to sponsor its shareholders, even if they are 100% shareholders in this new business. Scott, who heads up our accounting department, will then cover all the business logistical and setup aspects for this self-sponsorship route to be possible. I'll then close with a case study, bringing it all together with a real-life example, although the names and business names have been changed for compliance and regulatory purposes. It's important to mention that UK business expansion has to be a precursor to any immigration, and as such, Scott's input is key in the optimal business setup to enable an entity to qualify for their license. Moving on to introducing today's first speaker, Darren Faife. Darren has over 25 years' experience heading award-winning organizations and providing immigration and compliance services to large-scale multinational businesses. Having run his own successful immigration practice for over 20 years, Darren possesses a strong commercial mindset and provides an efficient delivery of strategic solutions. Darren has a wealth of knowledge and experience, and I've no doubt he'll be able to provide us with some great insight into the UK business immigration regime. So, Darren, over to you.
Thanks, Saskia. Hi, everybody. Thanks for joining us this afternoon. What I'd like to run through today is a bit of a whistle-stop tour of the UK points-based scheme. I think the idea of today really is to give you an idea and kind of demystify some of the terms you may have heard around the UK immigration process. And then you can kind of have a look at the various categories, think about which ones may be applicable to your own circumstances, and then certainly reach out to us afterwards and we can kind of discuss your particular circumstances and how you may qualify. We'll talk around the skilled worker visa. That's probably the most common route of entry to the UK for employment. Essentially, the new name for what used to be called a work permit or a Tier 2 visa. I'll also be talking about the sponsor license, which is something that all employers must have in order to have a skilled worker in the UK. And then there are some new visa categories under the global mobility banner, which includes individuals who are transferring from overseas within an organisation, which is the senior or specialist worker, formerly the intercompany transferee. And then there are some new categories such as the secondment worker, service supply worker, and I think what might be of interest to those business owners, the UK expansion worker. And Scott will then talk a little bit about how to actually achieve some of the kind of hurdles that you'll need to cross in order to get there. So the points-based scheme is talked about like it was a new thing. It was originally introduced in 2008, and at that time there were a whole myriad of different immigration categories, and the Home Office decided to reinvent itself, call it a points-based system, which was based on the Australian system, and bring all these immigration categories under 5 main tiers. And as the name would suggest, instead of criteria, there became a points system. In 2021, following Brexit, there was a kind of a wholesale change of how this points-based system was structured, making it a little bit easier in reducing salary requirements, skills requirements, advertising requirements, and also enabling people to switch visa categories once they're in the UK. And this will come into play a bit later as we talk about some of these visa categories that don't lead to residency, but the ability to, once you're here in one of the categories, you'll then be able to change status, which then does lead to residency. So it's really opened things up for those individuals looking to come to the UK on a more permanent basis. And then we'll also be talking about the expansion worker visa, which is, I think Saskia alluded to earlier, around business owners kind of self-sponsoring themselves and using that business as a vehicle of entry to the UK. So the key changes in 2020, so whilst we say that it was changed from 2021, it actually was implemented in December 2020. The key changes was there was no cooling off period under the old Tier 2 visa, which was replaced by the skilled worker visa. There was a cooling off period. So had you been in the UK and then left, you would need to remain overseas for 12 months before you come back again. So that was removed. They also removed the overall cap on the amount of visas that were available in any given year, which was, again, a very welcome move. And this is probably going to come into play even more as we are heading towards a recession. I think immigration will form a large part of us getting out of that. So to limit migrants who are contributing to the economy would make a lot of sense. So the cap has been suspended. There's no longer any need to demonstrate advertising, although the role must still be for a genuine vacancy. And the minimum skill level and salary has also been reduced. So we'll go into a bit more around that. But so skilled workers, as I said, replaced the Tier 2 visa. And this was in response to the UK leaving the EU. So what the UK had to do was to create a new system, which was a level playing field for both EU and non-EU nationals. So essentially, everybody's treated the same. And it's a point system, as I mentioned earlier. There are three main pillars of the system, which is the individual must have a job offer from an approved sponsor. The role must be of a sufficient skill level, which is now RQF 3. It used to be RQF 5, which was degree levels, now down to A level. And the salary had to be the prevailing rate of that occupation, or at least 25,600, whichever is the higher. And then there are also requirements around English language and criminality. So as I mentioned earlier, these three main pillars of the scheme enable the individual to score a core 50 points. These points are non-negotiable, so the individual must score these 50 points in these three areas. Okay, but in total, the applicant must get a total of 70 points, and the further 20 points will come from either salary. So if they are achieving the required salary, then they get the 20 points by default. So they're getting 100% of the required rate. If they're getting any less than that, down to 80%, they can score the additional points due to the role being specifically requiring a relevant PhD or being in a particular shortage occupation. And the shortage occupation is decided by a group called the Migration Advisory Committee, and they will sit and decide which roles in the UK are in acute shortage. And they produce a list, which is updated every 6 months to a year. And on that list, you may have certain specialty engineers, certain medical professions, etc. So before we can even look at getting a skilled worker visa, we must be dealing with an employer in the UK who has what's known as a sponsor license. And the sponsor license gives the employer the ability to issue what's called a certificate of sponsorship, which is a work permit. And with that work permit or certificate of sponsorship, the individual then applies for their visa and arrives in the UK. What the Home Office did is they gave employers a license to issue their own work permits. They're valid for 4 years, and it normally takes around 8 weeks to obtain. But the employer, in exchange for this facility, must uphold certain rules and fulfill certain obligations. And that will be around right to work checks, so preventing illegal employment. They must keep sufficient records. They must maintain contact details. They must know where all of their sponsored migrants are at any given time. And they have other certain duties around reporting to the Home Office, organisational changes and the like. So there is a responsibility on employers to be bona fide kind of, they are essentially the gatekeeper of immigration on behalf of the Home Office. And the Home Office will, as part of this contract, go out and visit those companies once every license life cycle, so once every 4 years, and they'll be assessing those 5 core areas that I just mentioned. So moving on to the global mobility routes. So what we just talked about was the skilled worker route, which is the main route. And that skilled worker visa leads to residency, or as we call it, indefinite leave to remain, after a period of 5 years. And after 6 years, so 1 year after, you can then apply for citizenship. Okay, so the skilled worker route is a direct route to settlement in the UK and citizenship. The global mobility routes do not lead to settlement. However, once you're in the UK on one of these routes, you are able to switch into the skilled worker route. So it can be used as a bit of a stepping stone into the UK before applying for a skilled worker visa. This scheme was launched in April 2022, so this year. So it's not been around very long. We've done quite a few. The Home Office are, I'd probably say politely, still getting to grips with it themselves. Some of these categories that are listed here are replacements for old schemes and updates, and some are completely new. So we're going to talk about 4 of the 5 today. The grad trainees are probably not going to be that relevant to you guys on this call today, but we will talk about the senior specialist worker, which is the intercompany transfer, secondment workers, service supplier, and the expansion worker, which I think is probably going to be quite interesting to some of you. So with the senior or specialist worker, this is a direct replacement for the old intra-company transfer visa. My slide seems to have got, there it is. And this is for normally a short-term transfer of a senior level individual or somebody with specialist skills that is required to transfer from an ascending branch to a UK branch. So quite often it is proprietary internal knowledge that they're being moved for. There needs to be some kind of common ownership control between the 2 entities. So it needs to be demonstrated that these companies are linked to be able to argue this proprietary experience. More often than not, the individual will need to have worked for the previous company for at least 12 months overseas, and they must have a salary in excess of 42,400. So the bar is a bit higher for this. As I mentioned earlier, on the skilled worker visa, the requirement is only 25,600 or the going rate. With this category, it's 42,400, and there are a specific list of occupations that fall into this. Most of them are there, but just be aware it's not all of them. The advantage of this category is there is no English language requirement, and this is very useful to, if you think about, Nissan, Toyota, some of these Japanese manufacturing companies with large operations in the UK. They'll use this category because it means that their employees do not need to learn English in order to come and do a 6-month assignment in the UK. It's one of the reasons why the category doesn't lead to settlement in the UK. It's not designed for that. And it also limits how long somebody can be here in any 6 years. It's a maximum of 5 years or 9 in every 10 years if you're considered to be a high earner. The advantage of the new scheme, though, is that somebody can switch, again, I'll keep using that term, switch from this category into a skilled worker category, which does lead to settlement. So a couple of years ago, if you came in on this category, you couldn't change status. You'd have to go overseas, spend 12 months, do your cooling off period, as I mentioned earlier, before you could then come back on a tier 2 visa. Now you could come in on this, and if circumstances change, you could then switch into the skilled worker visa, which would then enable you to qualify for indefinite stay after 5 years. So just looking at the two main ones here, the skilled worker versus this senior specialist worker. The skilled worker route doesn't have any previous experience requirement because you could be a completely new entrant. The salary threshold is much lower than RQF3, where the senior specialist worker is RQF5, which is degree level. So there's quite a difference in the benchmark for how skilled the role should be. Whereas on the other hand, the specialist worker, you can roll things in such as accommodation allowances and that kind of stuff, things which are typical of an international transfer or assignment. But fundamentally, I think if we kind of get towards the bottom of that table, the two main differences are around English language, and one that leads to settlement and the other one that doesn't. So moving on to this secondment worker, this one is a new category. It's not been widely used because it is quite narrow in its appeal. It's specifically for a company in the UK and an overseas business that has a high value contract, which must be at least £50 million overall, or 10 million per year. So it's quite niche. It is there, but it's not used massively unless you're talking about large industry. The individual needs to have worked overseas for at least 12 months. It's quite restrictive in the stay is only limited to 2 years. But on the other side of it, there is no salary requirement at all, where the others are dictated by a certain specific set of codes of what the salary must be. So it's one of those ones where I would doubt that any of you would be applying for, but it's useful to be aware of its existence. What's more interesting is the service supplier visa. And this is interesting because it also enables independent contractors to apply to come to the UK, where they have a contract with themselves or through their employer and a UK client. As with any of these cases, there has to be a UK sponsor, and that sponsor must have the right license to support a service supplier candidate. But if that's in place, then this is a category which is enabling individuals to come to the UK either through their employer or as a self-employed professional, and they can come for up to 12 months. There is no salary requirement again, but there are requirements around skill level and demonstrating that. If the individual is degree qualified and employed, then they need to demonstrate 3 years professional relevant experience. If they're self-employed, the bar's a little bit higher, and they need to demonstrate 6 years. Moving on to the expansion worker visa. Now, this is designed for businesses wanting to establish an operation in the UK. So that could be a branch or subsidiary. The requirement is that the main business must remain overseas. So the business shouldn't be moving themselves wholesale to the UK, but what they should be doing is looking to establish a presence in the UK. So the two are quite different. This replaces what was known as the sole representative visa or the sole rep visa, which was officially called the representative of an overseas business. This process is slightly different. They said they wanted to replace a cumbersome process, and I think arguably they've made it a little bit more cumbersome, but I'm sure that's open to debate. It's for a business to send up to 5 people to the UK. So whereas the old sole representative visa, you could only have the name gives it away, a sole representative to come and set up your business in the UK. Under this visa, you could send a team of up to 5 people to the UK. The main change here, though, is that the Home Office require the company to have a presence here already, so incorporated with Companies House, but not trading. And once you're incorporated, the company should obtain a license to then sponsor those workers into the UK as expansion workers. There are some exceptions around trading. There is a Japanese trade agreement, which means that Japanese businesses don't need to fulfill some of these requirements. But generally speaking, the company needs to have been trading overseas for at least 3 years. The license requires certain personnel to be in place, one of which being the authorising officer. And this authorising officer is the person responsible for all immigration activity from the business. And quite often that will be the person who's actually going to be coming over to the UK, unless the company is able to hire somebody locally in the UK in advance who can take that position instead of the person who's actually arriving in the UK. The allocation of a certificate of sponsorship is one, to bring in that person, then after which the company can change the license and then sponsor more certificates of sponsorship and skilled workers. Again, as I mentioned earlier, that license is valid for 4 years, and the company should be established and trading within 2. And now, often what will happen is the authorising officer, who's the expansion worker, will hire some local workers, have an infrastructure in place, and then apply to be a skilled worker themselves. At that point, that individual is then on this 5-year route to residency. So for a business owner, they could arrive in the UK as an expansion worker, get the business up and running, and then essentially self-sponsor themselves as a skilled worker, which will enable them to get residency in 5 years, citizenship in 6. So it's quite a good route for individuals who are already in business in their home country, looking to establish in the UK. I think the point here is that there still needs to be a genuine business need for expansion. We can't say to the Home Office, we're only applying for this visa for the purposes of immigration for this family. There has to be a business case around why the business wants to establish in the UK. If, as a result of that, the business owner comes to the UK and resides, that's fine. But it shouldn't be the primary purpose in any application we make. And I think we're going to go on to Scott. Saskia, if you're going to, yeah.
Sorry, taking a moment to come back. Thank you so much, Darren. That is really a lot of information, but you've managed to explain the new legislation in a very succinct, straightforward way. So thank you. I'll now introduce Scott Brown, who's been a part of the Sable International team for over 20 years.
Yes.
Scott majored in accounting and business administration in New Zealand. And after qualifying as a chartered accountant and working for 5 years within business services and tax, he headed to London and joined the First Contact team, which is now called Sable International. Scott and his team specialize in UK company formation and accounting, and I've never met somebody more passionate about payroll and well-versed in UK accounting. So Scott will be taking us through UK incorporation and the business logistical setups involved in expanding a business into the UK. Because as Darren said, the business expansion has to be a precursor to any immigration. Over to you, Scott.
Thanks, Saskia, for a very nice introduction, I guess. Welcome, everyone. I will give you a brief talk in regards to how to bring your business into the UK, how to set it up in the UK, and the requirements that are needed for that. Setting up a business or setting up a company in the UK is actually relatively straightforward. And if it's all done correctly and there's no sort of queries coming in from Companies House, then basically you can form a company here in the space of about 3 to 5 days. There are different variations of what you can set up. And the first one is, would you set it up as a subsidiary or set it up as a branch? Now, a branch is basically an extension of the parent company. It requires you to register the overseas entity at Companies House as having a UK establishment. Now, branches not everyone wants to do that because you have to report what the parent does to the UK Companies House. So basically the records of the parents is actually registered at Companies House. A subsidiary is actually a company in its own right. So while it still might be controlled by the parent company, it is a separate entity from the overseas entity, and therefore it has to file its own accounts and tax returns at HMRC and Companies House. So people might say, well, what's the benefit of one over the other? The advantages of a branch is the parent company stays in control. It does offer benefits to the parent companies, can easily be converted to a limited company later on if you want to, and it can be closed without any formal notice. So the setup and the operation of the branch is a lot simpler. A subsidiary, though, has a lot more freedom. So the subsidiary can be set up, operates as its own company. It can do contracts within the UK in itself, and we often find that when a business has been incorporated in the UK and dealing with UK suppliers, there's that interactions. They like that because they feel they are dealing with a UK company, not necessarily the branch of an overseas company. So the requirements of a subsidiary or any business really. So there's three main areas that you need to look at. The first is the appointment of the directors. Now, when you incorporate a UK company, the directors do not have to be UK residents. So it doesn't matter in what country they are based, you don't actually have to have a UK person here at all as a director. Might want to do it, and I'll get to that in a minute. But the next thing you need to look at is the appointment of the shareholders. Now, the shareholders can be anyone from individuals, they can be trusts, they can be limited companies. Again, it doesn't really matter. They don't have to be resident within the UK at all. So you can set up a UK entity whereby the whole company is actually owned and controlled by people that are non-residents within the UK. Next thing you need to look at is your registered office. The registered office is where if HMRC or Companies House need to get in touch with you, they send it to the registered office. So often that's not the case. It's not the same as your trading address. Trading address is obviously where you do the business from. When you first come over to the UK, or when the business first gets incorporated in the UK, they don't necessarily have their own bricks and mortar office. So the registered office is often an accountancy firm such as ours, because the registered office is part of the Company House notifications. So it is a public domain, so anyone can look up to see where the registered office is. And individuals don't generally like to put their own private address on. So a private address can be the registered office, but often we find that someone will use an accountancy legal firm because they don't want their private address added to Companies House. Finally, with the share structure, ideally when you're setting up the company, the best thing is to keep it as simple as possible. And the reason behind that is regarding the tax, setting up the bank accounts. But we'll get to that in a minute. Once a company is set up, there's certain areas that need to be looked at in regards to registering it for taxes. Corporation tax is already done for you. That's once a company is set up, that automatically happens. But because the company needs to employ people, there are three areas that have to be looked at here as an employer. The company has to register as an employer, and that takes about 2 to 3 weeks. It needs to be done around about the same time you're looking at employing someone. You must get employer's liability insurance as soon as you start looking at employing people. It's a compulsory insurance within the UK, and you must operate with it. You should also get employment contracts sorted out, and with that deal with someone with an HR or a employment lawyer. The idea is you don't want to be using employment contracts from your own home countries. The UK law is very specific and is geared very much towards employees. So you do want to make sure that your employment contract is correct. You also need to look at auto-enrolment, which is the compulsory pension scheme within the UK. You must offer that to your employees. They don't necessarily need to take it up, but the offer must be there. The last tax you need to look at is VAT. VAT, you do not need to register for it until your sales reach 85,000, but you can voluntarily register for it. And you find that for a lot of companies who are operating, have got the suppliers and everything and are being charged VAT, they want to register early so they can claim some of that VAT back. Opening a company bank account. A lot of the things that I've said up until now will lead to this point. Obviously, you want your own company bank account to be set up and to be operated. And ideally, you want that also set up within the UK. You would think this would be one of the easy steps, but unfortunately, the banks have made this quite difficult. And whereby I said before, where directors and shareholders don't have to be UK residents, banks generally do want at least one director and possibly the majority shareholder to be UK residents. There are some online banks, and there is one of the high street banks that do allow companies that only have non-resident directors and shareholders to set up a bank account. However, quite a lot of compliance is needed to do this, and also those options can be fairly expensive. So when you're looking to set up the company, ideally you want to keep it as simple as possible. It might be just one director and one shareholder. And if that person is based in the UK, it will make things a lot easier in regards to the bank account. So again, it's not possible to set up a bank account when they're not non-residents, but if you're going to do that, don't expect to set up a company bank account quickly. There will be a lot of compliance that the banks will do, a lot of checks that they will do, and especially if there are corporate shareholders or trust involved, the banks will want to know all the details of those. In the statutory filing and requirements, so all companies here must file a set of accounts at Companies House and also HMRC. The account period is 9 months after your year end, and your year end in the UK is based on the month that the company was incorporated. So if a company was incorporated today, being the 16th of November, the company's year end would be the 30th of November next year, 2023. And then you have 9 months after that period to file the accounts, get the corporation tax return completed, and submit both to HMRC and their set of accounts to Companies House. There are, as I said, strict time frames of when the filing must be done, and the penalties and fines and interest are quite high if those are not completed on time. So setting up the company, getting it operating is actually relatively simple to do, but you need to seriously think about who your directors are going to be and who your shareholders are going to be, and then they have the best setup so that the advancement of the company, getting the company bank account open, will become a lot easier from there.
Perfect. Thank you so much, Scott. Always great to get a really detailed understanding of how that company incorporation works. So thank you very much for that. I see we have a few questions. We'll come back to the questions afterwards. Thought I'd just take you through a little case study around self-sponsorship and how it looks in practice. So essentially bringing what Darren's spoken about and what Scott's spoken about together. So this was based on a real case that we did about a year ago. We have changed the names and the business name just for compliance and regulatory purposes. So Peter was South African, 2 children under the age of 18 and a spouse. He really wanted to relocate to the UK, but didn't have any UK ancestry or any claim to British nationality. His age was also a factor against him. He's 60 years old. And when he was looking at internationalizing himself to some other jurisdictions, often his age counted against him with the, say, Canadian or New Zealand point-based system. Doesn't have a factor in the UK. So Peter engaged with us and we discussed the self-sponsorship route. He's been an entrepreneur in South Africa for very many years. So he's run successful businesses there. And he had a business idea that he wanted to go ahead and incorporate in the UK. He also had a business partner already resident in the UK, and together they decided they wanted to go on this venture in the first instance to expand the business and then to use that business as an immigration vehicle to ultimately relocate to the UK. So his business partner was Lucy, based here in the UK. She already had a British passport, although she was originally from South Africa. And because she was based in the UK and a resident director in the UK, made it quite a lot straightforward for them to go through the incorporation process with Scott and his team and to get the all essential UK bank account. Lucy was also able to serve as the business's authorizing officer with the Home Office. So she met the requirements of being that first employee on payroll in the UK, which is required before you apply for a sponsorship license. So we went through that process. They were registered with HMRC and all the points that Scott mentioned in terms of auto-enrollment, a VAT, etc. And then the business was in a position that we could apply for the license. So we then went through and got the business a sponsorship license, and then we did a 5-year skilled working visa for Peter and dependent visas for his family. So they could all essentially get on the plane from South Africa and relocate to the UK. Peter's wife, which is a common question about the dependence of a skilled worker, could work free of immigration restrictions, meaning she could be self-employed or employed or not work as they prefer. And after 5 years of living in the UK on a skilled working visa, they would qualify for indefinite leave to remain, which is commonly known as permanent residency. And a year after being on indefinite leave to remain, then they may qualify for naturalization. So it's commonly known as kind of the 6th route to British nationality, whereby we went through the process, helped Peter incorporate his business here in the UK, and then use that business as an immigration vehicle to relocate him and his family, who are all now in the UK, and in about 4.5 years' time will qualify for indefinite leave to remain. So that's just a little case study. And then we'll go through a few questions and answers. So Darren and Scott, if you want to come back on, we've got time for just a few questions.
Sure.
So Darren, the first one is for you. Why would a company opt for an intercompany transfer visa versus a skilled working visa where the candidate can speak English?
Sorry, I didn't catch it on the mic. Sorry.
Why would a company opt for an intracompany transfer visa, the new intracompany transfer visa specialist skills, versus skilled worker where the candidate can speak English?
To be honest with you, most situations where there is no English language barrier, a lot of companies will just opt for a skilled working visa. It's a lower salary requirement. The skills threshold is also lower, and the individual then does qualify for indefinite leave to remain after 5 years. What we've seen are less and less companies actually using the intercompany transfer or senior specialist worker visa because of that very reason.
Perfect, thank you. And another question, can a sole beneficial owner of a business qualify for the UK expansion worker route?
Yes, indeed they can. I think this is the biggest change with the sole representative visa. Is that, can you hear me okay? Because the mic seems to be sounding a little bit odd on my side.
I think there's a bit of feedback. Scott, if you maybe pop yourself on mute, I think we can hear it from your screen.
That might be better. Yeah, I mean,
there we go.
That's much better. The big change really was around that. Under the old scheme, the major shareholder, so anybody with more than 50%, wasn't able to benefit from the sole representative visa. Under the UK expansion visa, there is no such restriction. I think I mentioned earlier there is a point that the main body of the business should remain overseas, and therefore the sending company should still be the main part of the business, with this UK entity being a smaller portion of that business. And so I think there is potential for some challenge from the Home Office to say, well, look, you know, if the owner, the controlling mind of that business is moving to the UK, how can we be satisfied that that overseas business will continue to operate? So I think as long as we can field that question, and you know, let's be honest, we're going to be talking about quite often an established business in its home country. So therefore, it's, you know, it's probably its client base and its footprint will be much bigger at home than it would be in the UK. So it's something that the Home Office may ask a question around, but now it's something we can actually achieve, whereas previously we couldn't.
Brilliant. Thank you. And the last question for you, Darren, with the UK expansion worker, what if the business was incorporated quite a few years ago but isn't yet trading? Do you think they would qualify?
Yeah, as long as it hasn't traded, and that's the most important thing. It can have a footprint, but not a trading one. So the Home Office would check. I mean, they would check with Companies House and have a look at previous filings. If it had been a dormant business, so it had been incorporated and nothing else, then we could still use it.
Perfect. Thank you. And then, Scott, we've got two questions for you. The first one is for a micro business with just one beneficial owner, would you suggest a subsidiary or a branch?
I'll probably look at subsidiary in that case. I mean, the fact is, you're here in the UK to set up your business and operate the business. So do you necessarily always need to be attached to the overseas business? Perhaps not. And if you're going forward and you're building your client base in the UK, and I mentioned, the UK likes dealing with UK companies. So I think most cases, I would always suggest the subsidiary route.
Brilliant. Thank you. And last one for you. Can you help a newly incorporated business comply with all their statutory requirements?
Yes, for sure. As an accountancy business, we can help them complete their accounts, make sure they're all their filings up to date, deal with HMRC and Companies House on their behalf. So yes, no problem at all with that one.
Brilliant. Thank you very much. I think that's all from us today. Everyone on the call will receive a copy of the recording, and all our contact details will be emailed afterwards. So if anybody would like to have a further conversation, you are welcome to reach out. The first consultation is always on us. So thanks very much for your time today.
Thanks, everyone. Thank you.
Thank you.